Hello, everyone. Welcome to the next episode of the Justice Revolution. I'm your host, James the Patriot. Have my beautiful co-host, Justice. Say hello, Justice.
Hi, everyone.
Producer. I always got to remember that part. Erica is off today. She is helping out, I believe, with her sister. I can't remember the story, but she's helping out, so she won't be with us today. And I apologize. I know we had originally put this out. We were going to have two guests on the show. One of them wasn't able to attend. He got held up at work. That's Steve. So we'll catch Steve on the flip side. But I do want to welcome my guest, Kirk Pendergrass from Kirks Law Corner. Kirk, say hello.
Hello, James and Justice over there. Thank you for having me on today.
Thanks for being here. Really appreciate you being here. So,
So
real quick, since this is a live episode, for those of you who are following along live, please feel free to post any questions in the comment section. We'll put them up on the screen as we can. But I really wanted to just make this, for those of you who may not be familiar with Kirk and what he's doing. Kirk, you've been doing this for how long now? 15, 20, 30 something years?
Yeah. I've actually just been studying law out of necessity, right? You know, sitting in a jail cell in 1995, dealing with the corruption and the threat of, well, if you don't take this plea bargain, we'll go to trial and make sure you lose. And, you know, I'd previously in the traffic ticket, I had proved that the police officer did not have probable cause by myself, 1995, April 19th, 1995. So, you know, I told him about that, the public defender, and he just basically said, well, either you take this plea bargain, we'll go to trial, you'll lose, and I'll make sure you get the maximum time in prison. And I'm like, whoa. So, you know, I'm like, you know what? I'm not going to get screwed like this again. So sitting in a jail cell, going to the law library within the jail, 1 hour a week, and just started studying law. And, you know, that's been 28 years.
Yeah.
And I really, really hit the books hard back in starting basically 2014. At that time, I was running my own mechanic shop, and I just started getting to the point where I couldn't focus anymore on my work. And this is all I could do was read law, study law, and like got to get the people educated on the law because it's our republic if we can keep it.
Yes.
Knowledge is power. Without the knowledge, we have no power. Then we have to learn how to wield that power. It's like, you know, the Bible says our tongues are sharper than a double-edged sword. So when we become the lawyer, one who speaks the law, yours to speak, has nothing to do with the bar. That's a major misconception. So when we speak the law, we can, in the spiritual realm of things, we're wielding that double-edged sword by spelling it out, casting our spell. So it's all about writing, putting it down. And the first fundamental principle of due process of law is notice and opportunity to respond. And
to be heard. Correct. Yeah.
Right. So, I mean, this gets back to basic civility between man and man, whoever it is, hey, look, what you're doing is wrong here. Please stop. Cease and desist.
Yes. Yes.
Common decency.
Yes. No, that's a great introduction, you know, for a lot of us and for a lot of the people that tune into our broadcast and to, you know, we put this up on podcast as well. So some folks might not be watching, they might be listening. And if you're listening, thank you for listening. We appreciate you being here. But, you know, it's rare to find people like Kirk, people like Randy Kelton, who's been doing this for 30 something years. I mean, it's rare to find people like that. But we're finding that more and more these days. I mean, if there's one thing that the big C, because we're still on some platforms, I'm not going to go there, but the big C taught all of us, it's like, hey, wait a second. If we were just going along to get along, that is not the way to do this. Because it's like Thomas Jefferson said, you know, I've said this before, and I'll say it again. Those people who expect to be ignorant and free expect what never was and will never be. So we cannot be sitting on the sidelines anymore. We can't be doing things that we think we should be doing and expecting a result. I mean, isn't that the definition of insanity according to the Chinese, Kirk?
Doing the same thing over and over again, expecting different results.
Bingo. You know, I want to touch on something real quick. I want to get your thoughts on this, Kirk, and then we'll jump into the topic at hand. But we have all we have all been following, I shouldn't say following, we've all been hearing about the Brunson v. Adam case, right? We've been hearing about this case. It fast-tracked its way to the Supreme Court. It was put on the docket for the justices to review, and that was back in January. Well, the justices declined to hear the case, rightfully so. I've got my opinions on that. I know, Kirk, you do as well, which I feel like those are very well founded. However, I noticed yesterday that Raylan Brunson posted an update that it's been redocketed, and now they're hoping again. So my question is, isn't this just the definition of insanity? If they declined it the first time, aren't they going to do that again? And if not, why would they not do that? I guess, I don't know. I see this and it just doesn't quite make sense to me. Why would they put this right back on the docket again if they've already said, no, we're not going to take this case up? What are your thoughts on that, Kirk?
Well, I think what we need to recognize here is the steps that's been taken. Okay. Mm-hmm. First of all, this was filed in the district court.
Yes.
That is the trial court.
Yep.
Okay. And the opposing parties had made a motion to dismiss, lack of standing and lack of subject matter jurisdiction.
Yes.
Now, everybody wants to focus on the lack of standing and never focus on the lack of subject matter jurisdiction. Mm-hmm. The real question here is, what is the subject matter?
Yeah.
It's elections.
Yeah.
So the next question is why does the judicial branch keep saying that they don't have subject matter jurisdiction over elections?
Because that's a political question, not a judicial one, right?
Bingo. This is the political doctrine question, yes. Which has judicial branch has zero jurisdiction. Absolutely none. And if we read the Constitution, Article 4, Section 4, on application of the legislature mm-hmm. or the executive if the legislature cannot be convened. This mm-hmm. is our Republican form of government. And again, the supreme law of the land yep. is literally due process of law. So Article 4, Section 4 is dictating the process and which parts, the branches of government has what power. So now they didn't like their case being dismissed. They have every right to appeal. So yep. they went to the appellate court of Utah, and Utah affirmed, no, there is no jurisdiction and there was no error in the trial court. Okay. Yep. They didn't want to accept that answer, have every right to go to the Supreme Court of the state. And the Supreme Court just affirmed that the trial court was correct in their analysis. They didn't mm-hmm. like that. So yes, the next step is to the Supreme Court of the United States of America under a writ of certiorari, which is originally a writ of error. Yep. Right? Was there yep. the writ of certiorari is a simple question. Did the trial court make any errors? That's mm-hmm. all that does. The Supreme Court is not a trial court. Neither is the appellate court or Supreme Court of a state. So we mm-hmm. have to comprehend what this really is. And writs are from the common law. So yep. this is how the Supreme Courts have original jurisdiction under the common law for writs. Mm-hmm. So writs of error, writs of mandamus, writs of prohibition, writs of habeas corpus. Those are all common law yep. writs. Yep. So the Supreme Court of the United States already, and see, that's the other thing. When you file these types of writs, they have to hear them. They don't mm-hmm. get to deny those because this is common law jurisdiction. They're yes. required to take them up and hear it. Mm-hmm. So this idea that, the Supreme Court took the case. No, yeah, first of all, the Supreme Court didn't take the case. They're required mm-hmm. to hear the writ.
Yes.
That they're required to read court.
Yes, so they're required to read
the subject matter jurisdiction and which branch of government has that power. Well, mm-hmm. Article 4, Section 4, our right, First Amendment, or Article the First of the original Bill of Rights, the right to petition government for the redress of grievances. Now, when we get into our state constitutions and look at our Declaration of Rights, the law being laid down before the Constitution, mm-hmm. We'll find in every single one of them the right to petition. Yep. And some will actually specifically state the legislature, like mine does, Article 1, Section 10. The right to peaceably assemble has to do with assembling the General Assembly, the legislature, to redress our grievances, to consult for our common good, to instruct our representatives, and to petition the legislature for the redress of grievances. So this is a right, real law, because right, actually the word right and law is synonymous, comes from the French word droit. So Declaration of Independence, that to secure these rights, governments are instituted. Hale versus Hinkle, this is great. One, our rights are long antecedent to the formation of the state, formation of government, organization of government. The next part that it talks about that most people that have read Hale versus Hinkle are missing is the next section right below that, where it talks about there is a reserved right in the legislature to do an investigation to see if they have exceeded the laws of its creation.
Yeah,
and this brings up the question, what the heck is laws of creation?
Yeah, and real quick for everyone, just so you know, we're talking about corporations. Hale versus Hinkle was a case where an individual was refusing to incriminate himself, and they were trying to prosecute him as though he was a creation of the state. So just to bring everybody up on the speed.
Well, there's a little bit different. There was a corporation, the plate glass and their shipping, this is trade, personal jurisdiction. And another part that's mentioned in Hale versus Hinkle, that there is a clear distinction between an individual and a corporation.
Yes.
This is prima facie that there is no personal jurisdiction over an individual. So if there's no personal jurisdiction over an individual, then there's definitely no personal jurisdiction over man. See, we have to comprehend these words. Individual is a member of a corporation or an organization, an agency, an agent, an employee. Okay.
Yes.
So if there's no personal jurisdiction over an individual, then there's definitely no personal jurisdiction over man, which goes back to the rules of the common law in like court cases, pleading in the form of demur from the rules of the common law. And it's objecting to the personal jurisdiction. So this is part of what I teach from the rules of the common law, right from my own common law pleadings book, right from the Criminal Practice Act of 1864 for the territory of Idaho. It's a Criminal Practice Act right in there, pleading in the form of demur.
Yep.
So why are we not reading this stuff and learning how to effectively defend ourselves? Because we talk about sui juris, right? Lawful age, of sound mind, and that's right, perfectly capable of handling our administrative duties,
our own affairs.
Are you capable of doing the paperwork? Because everything has to be done in writing. And this is so crucial, because what we're actually doing is creating the court of record. Our documents is actually the court, not the venue. The venue is just where court is held for hearings, because Lady Justice is blindfolded. We have to hear. So if there's anything that needs to be heard where there's an objection, that's where the venue is where we go to hear. Venue is not jurisdiction. It's just the place of hearings.
Yeah.
I have a question.
Yeah, I was going to say, go ahead, Justice.
So as the last few years have gone on and people have been defending themselves, they come across these situations, and the judges and these institutions clearly don't recognize that. So it puts us all in a position, and people are very lost as to which way to go and how, which is, I know, part of the subject of our discussion today, but have you had remedy to that with, I guess I would say, a lawful justice that abides by the law versus someone that doesn't? And then, what's your redress on that, I guess, as we get to it. So
this is what I refer to as the long game. Okay. Everybody's so narrowly focused on trying to win in the initial court that we go into, which are the de facto kangaroo courts. They don't recognize the Constitution because they're acting under a foreign jurisdiction. And they play the game of, we're going to do whatever we want to do. Catch me if you can. So we have to learn that fundamental principle right there. Don't get upset. Don't try to argue with them. Create your court of record. Make your short, clear, concise statements of facts at any hearing. Don't answer any questions. Just everything's done through paperwork, and you just talk about on the record what's in the court of record. And this is key, because when the other side tries to start talking, immediately objection.
I object.
Your facts on the record that are not in evidence.
Not
only that, Trinzi versus Pagliaro. Attempting to enter facts on the record or whatever statements made by the the attorney or prosecutor on the other side may be enlightening to the court, but they have no firsthand knowledge and they cannot testify from over there. You want to testify as a witness, you got to take the stand and be sworn in under oath.
Yep.
Testify, be available for cross-examination.
Mm-hmm.
Well, they can't do that. So this is how I shut them down over there and put a zipper on their mouth, keep them from talking, because I haven't been served with anything.
Yep.
So,
real quick, Kirk, I don't want to cut you off, but just to further that point, we had a situation in one of these cases that we're litigating. And again, this isn't the time to go over that. However, we had these liars interjecting their crap. And so we filed an objection and say, hey, listen, we object to them opening their mouths at all. If they want to open their mouths, they're going to need to be putting everything into the record under a sworn affidavit. So I even included the affidavit that they could sign. And they replied back, yeah, we're not signing that. Okay, good. Then it means to me that nothing you say matters because I really don't care. But that's what Kirk is talking about. Every time a liar opens their mouth, object. This man or woman has no personal knowledge. They cannot testify. And if they're testifying, they need to be put under oath.
If it's not in the existing paperwork, correct?
Exactly. So, I mean, this is how asinine this is. And we'll get back to where you're going, Kirk. I apologize for cutting you off, but This is how ridiculous this is. I just noticed in one of the Telegram groups, an individual posted a motion for judgment on the pleadings from the defense. It's a 45-page motion for judgment on the pleadings. Guess who signed it and guess what's not included, Kirk? You want to take a guess?
Findings of facts and conclusions of law.
There's that. The liar signed it, and guess what's not accompanying it that's required to be there?
An affidavit?
There's no affidavits.
Imagine
There's
that.
nothing that says that there was a deposition taken under oath. There's no answers to interrogatories. Nothing.
Yep.
So, again, people, this is the thing, is if you let these idiots get away with this, they're going to get away with it because, well, this is how we've always done it. I don't care.
Exactly.
It's not how, this is not the law. This is not how due process works. Because a court, and that's one of the things I love about the Trinzi v. Pagliaro, is the judge, and that was just a district court case, by the way, and it's still solid case, people.
Yep.
1964. That judge says, hey, we appreciate this judge, this lawyer putting this information in here. It's enlightening to us, but it means nothing. Unless there's an affidavit, unless there's a deposition on file, we, the court, cannot consider anything these people say.
Absolutely.
That means any motion to dismiss, anything, if it's not supported by an affidavit from either one of the named defendants, if you're the plaintiff, or other way around, if they don't have that information, the court has no facts to rely on, and they have deprived the court of the subject matter jurisdiction that court needs. Sorry, go back to you.
Absolutely. And these little things, that we need to know how this is supposed to work, and we need to play our own game. And I like to refer to going to court as like a tennis match.
Yeah.
Okay. Is that referee actually on the court? No, he's a disinterested third party on the outside calling balls and strikes. Anytime there's an objection, that's when they pay attention. Otherwise, they're just a bump on a log sitting over there watching the ball go back and forth. So the ball is your paperwork. And so, let's say you use a traffic ticket. Okay, they give you a traffic ticket. You've been served. You've been put on notice. And I explained this mathematically, which I learned this from Christopher Hallett, and how to apply mathematics to this being logic and reason, fundamental principles of mathematics. It's called the negative nexus. -1 times a -1 equals a +1. So what we have here is the first -1 is a lie. Is the officer giving us a ticket of some sort, which can turn into misdemeanors or even felonies, right? But where was the standing and cause of action? But it's a lie. So that's a presumption in the record. Mm-hmm. The second -1 times -1 is the prosecutor doing the complaint and filing it with the court. So now there's the two lies, and here's the referee on the outside of the court looking at the court of record going, well, this guy's been served. He's been put on notice. I see no objection. So I have to assume that this is true because there's no objection. There's no rebuttal. And really all it needs to be is an objection. Mm-hmm. So the thing is when we do that, we're hitting the ball back. So who's at fault if we don't do our paperwork and respond with a pleading?
Yeah, that's us.
And this is where I softened my heart a little bit in comprehending that we've all been lied to. We've all been dumbed down. All of us, including the members of the bar, the judges.
Yes.
Right. And start having compassion for our fellow man and realizing that we've all been lied to.
Mm-hmm.
Nobody knows. Nobody alive today that lived in a time period where this was all legitimate. No, this is all de facto garbage. It's foreign, totally foreign to our form of government, repugnant to our law.
Yeah.
But knowing this, and, I've talked to other members of the bar that have been in there for 60 years. Fred Kelly Grant wrote a couple of books, Justice My Ass. Okay. And he explained to me, he's like, look, as a judge's clerk and all this stuff, the judges half the time complain that their hands are tied. They can't do anything. They want to grant relief, but it's not proper before them.
Yes.
They're stuck. Their hands are tied. So this is the key. We have to do the paperwork so that the referee, the judge, is looking at the ball going, okay, yeah, you hit the ball back. Now you just remove the presumptions from the record and the judge cannot assume anything.
No.
Now we got to go with facts.
Yes.
And evidence, because truth doesn't become fact without evidence.
Correct.
It's a three-pronged test.
Yep.
So what we have to recognize is this game that's going on. And if the other side is cheating, or even if the judge steps on to the court and starts taking jurisdiction where he has none, he just becomes culpable. And for me, I try to teach, but just sit back and smile. Okay. You want to play this game with me, that you're going to do whatever you want, catch you if it can. Okay.
I'll play your game.
I'll just, walk silently, but carry a big stick. And I have a big one, let me tell you.
Yep.
So I'll just, you want to play that game with me? Fine.
Yeah. What were you going to say, Justin?
What's the next step? What's the remedy? First of all, if you're challenging jurisdiction, the common law writ of prohibition, bam, straight to the Supreme Court. Look, here's the record. I challenged jurisdiction. I gave them notice. I told them I don't consent, because that's what that really is.
Yes.
And they failed to prove how I'm bound by this code, which is all made up by the bar.
Yep.
So in the basis of this, I would have to be a member of the bar for it even to begin to apply to me. And I'm not. So how would it even begin to apply to me? It's not law. It's code, CODE, not law, LAW. So
and real quick, Kirk,
under writ of prohibition, you could do a constitutionality challenge to what just happened. Then you do your petition to the legislature with your order from the judicial branch to abolish this, or to do an investigation to arrest that officer, to arrest the prosecutor, to arrest the judge, and they go to jail. And we shut this stuff down. Yeah.
This is why it's so important, people. I mean, you guys, this is a massive process, right? Most of you guys are being dragged into, I call them kangaroo courts. I mean, and I that's not my term. I stole that from Alphonse, but still that's kangaroo courts, because they operate like, you'll walk in there and you go, I have a right to face my accuser. Nope. Don't bring that constitutional stuff in this court. You'll hear quote unquote judges say that. So the minute you hear that, you're like, okay, I have done my job. I have objected in writing. I have challenged jurisdiction. The moving party, which is the prosecutor, it's now incumbent upon them to prove to the court on the record they have jurisdiction, which they never will, because they can't. So if that judge just says, yeah, I've got jurisdiction to hear this, the law says I do. And if he just moves right on, okay, your next step is like, all right, for those of you who are listening, I'm just sitting back, folding my arms. It's like, okay, go ahead, whatever you're going to do. Because my next move is going to be like Kirk just said. I'm going to file a petition for a writ of prohibition. All of this stuff is out there, guys.
Yeah.
It's all under the, you can find all of this information. Just do a quick Google search for a writ of prohibition. You'll find samples. Go to your state Supreme Court, find out how to get one done. And you take your record. You say, I properly challenged jurisdiction. I supported that challenge under oath, under the pains and penalties of perjury. It went unrebutted. I am entitled to default.
That's right.
But they are denying me that right. That is a denial of my procedural due process rights.
Absolutely.
And sorry, go ahead, Justice.
And the judges, when they say this, it's our duty to prove them wrong, is it not?
Exactly.
Because
No. Burden of proof shifts as soon as you file your notice of special appearance objecting to the personal jurisdiction and your motion to dismiss. That shifts the burden of proof on the other side.
Okay.
Yeah.
So when the judge tells you you don't bring that constitutional stuff in this court, he just overstepped his boundaries, right? And he's got no jurisdiction, is what you're saying.
He has no okay. Judicial immunity only applies when everything lines up for that judge. Okay, I have a proper pleading before the court. The other side has received notice. They've been served with a summons. They've received a copy of the complaint. I see that there. Oh, I've got an affidavit that it's been served. I've got that. Perfect. Now let me read the pleading. Okay, what are they moving under? Is this a common law cause of action? Is it a statutory cause of action if they're moving under the codes? Okay, do I have, according to this, do I have that authority? Great. Oh, and is there an affidavit of someone with standing? Is there an injury in fact? Can they prove they have standing?
Absolutely.
Right.
If that stuff is there, now the judge, he has judicial immunity. But in these municipal courts, I don't know what they're called in Idaho. Here in Utah, they're called justice courts. I call them injustice courts because there's no justice being done there. They're railroading people. I've got this lady that I've been helping out, and it's a very similar story to what you went through, Kirk, where I don't know, for lack of a better term, they're falsifying charges of violating a non-existent jail agreement order against a woman who allegedly hurt her partner when he refused to press charges. So we have no affidavit from a victim anywhere. And now they're trying to throw felony charges at her. And her defense attorney says, if we go to court, you'll lose. You need to take this plea in abeyance. This is a good deal. I mean, it'll make your freaking head spin.
Yeah.
So
good for the attorney.
Yeah, so that's the process. What we wanted to, God, here we are, half an hour into this, so we're getting to the heart of it.
I just wanted to kind of make it clear that people understand, since it's kind of the subject of what we talked about, is that when do you know the judge has overstepped their boundaries? Because you go in, someone, that's all new to this. You have no idea. They're very authoritative. We've been programmed to be frightened. They tell you what's what, and you don't even know they've overstepped their boundaries, right? So I just wanted to kind of reiterate again so people understand, and you're talking about administrative courts primarily, are you? Or all courts?
Well, and that's just it, is all of these municipal courts, you're going to be hard pressed to find any of them that are going to prosecute you constitutionally.
Okay. Because
it just doesn't exist. I don't remember the last time I even saw one. I mean, you just look at the pleading, you look at the information, or you look at the indictment. None of them say the people of Utah or the people of Idaho versus. They all say the state of in all caps letters. They say the city of. They say the county of. I mean, that's an administrative proceeding. So
no, that's actually not either.
What do you mean?
It's kangaroo. Yeah. It's de facto. It's not a legitimate court to begin with. People are trying to say, oh, well, it's admiralty jurisdiction or it's administrative. No, it's not. It's all just fraud.
It's a simulation of legal process.
Bingo. I mean, it gives the illusion.
Yes.
The illusion that you're getting due process of law over here.
No.
So here's the first maxim of law. The defendant by pleading or exception becomes the plaintiff. Okay. The burden shifts when we do an objection. Now, the other side has to prove whatever you've objected to, whatever, lack of personal jurisdiction should be number one, because that's pleading in the form of demur, and that has to be determined first. Mm-hmm. So what is the person? Not man. Back to Hale versus Hinkle. They only have personal jurisdiction over corporations and that which they create.
Mm-hmm.
So this goes back to an ideological conflict between the monarchy and Catholicism, where the king is the sovereign, versus Christianity as an ideology where God is the sovereign and we're creations of God. and endowed by God, our creator, with certain unalienable rights, the laws of nature. And so we get back to this Roman civil law, the code, because that's what the code is the Roman civil law, which all came in re-implemented here in America through the Reconstruction Acts of 1871, created the American Bar Association in 1878, and brought the code, the Roman civil law, under the monarchy, under Catholicism in 1881, the Code of Civil Procedure.
Yeah.
This is when they changed, fundamentally altering our form of government and subjecting us to pretended acts of legislation that the Declaration of Independence refers to. This is what the Magna Carta was about in 1215, was because the code was all lost back in 600 AD and then was recently discovered in 1130. So they tried to re-implement this Roman civil law, the code, where the king is the sovereign, because Constantine in 300 AD there switched from Catholicism to Christianity. And so they flourished then. Okay, well, that's what's going on again in history over and over and over again. It's the same thing. And by statutory act of England in 1881, extended the High Court of Admiralty of England over here.
Yeah.
They basically converted us back into a monarchy, which goes back to what our founders put in Article 4, Section 4. And what that argument was to keep us from having even one state turning us back into a monarchy.
Yeah.
So if we comprehend why that was written, the way it was written by our founders in Article 4, Section 4, and what that is actually used for, that's the remedy and relief that we have the right to demand. And so back to the judge, Ultra Vires, when that judge or justice of the peace or whatever you want to call him, the referee, fails to grant relief when it is demanded, that is Ultra Vires. He just lost all immunity. But where do you have to go for that? The legislature, Article 1, Section 2, Declaration of Rights under the Idaho Constitution, is all political powers inherent in the people. We have the right to alter, reform, or abolish anything at any time we deem it necessary. And no special privileges, Hale versus Hinkle, or immunities shall ever be granted that cannot be altered, revoked, or repealed by the legislature.
Here in Utah, folks, it's Article 1, Section 1, inherent and inalienable rights. We have a bunch here, but it says right here, and petition for redress of grievances. See, I think where people get confused is they see this petition for redress of grievances. Okay, great. Where?
Mine specifically says petition the legislature for the redress of grievances.
Yeah,
Article 4, Section 4 specifically says the legislature.
I wish we were. There's, and here's the thing: is like there's some states' constitutions are much better than others.
Yes.
Be serious. I mean, that's how it is. I mean, Idaho specifically spells things out. Utah is very vague in some things. However, one thing that is not vague is Article 1, Section 26. Article 26. It says the provisions of this Constitution are both mandatory and prohibitory. So that lays it out right there. That basically, if it's not listed in here, you cannot do it. If it's here, you must do it. That's how it works. So we can do this. So let's go back to our example here, right? You have property challenge jurisdiction. You've filed a petition for a writ of prohibition, and now you're like, okay, where do I go to get a redress? We've been told like, well, you need to file another lawsuit. Well, again, guys, does this make a lot of sense to you, given the fact that you file another lawsuit? These people all know each other. They're all members of the same organization, the bar, right? And by the way, Kirk, will you tell people what the bar stands for? I've told this before, but
British Accredited Registrar, or sometimes referred to as registry, but it's registrar. It's a registry.
British.
But it's British. From the Crown Temple Bar.
This goes
the
all back to
International Bar Association.
There you go. It goes right back to church. It goes right back to what Kirk was saying. It makes total sense. So they took our beautiful justice system and they've been slowly deteriorating it over time. So if you think that the redress is going to be there and you're not getting it and you're just beating your head against, well, I know I've been doing this, I've again, for lack of knowledge, not because I didn't want to, it's because, oh my gosh, it didn't even dawn on me. So let's talk about that. The title of our show, here we are, 37 minutes in, we're getting to it. We'll get there. The title for the episode today is petitioning the legislature for redress or grievance. So talk to us about that, Kirk. What does that process look like? How do we do it? How do we get a petition to the legislature, and how do we do that process?
Well, it's actually a lot more simple than we would think. This is something that Christopher Hallett introduced me to back in 2017. And, there's rules of procedure for the House and the Senate and joint rules or general rules of procedure. And I was like, wait, what? I thought that's all judicial. No, there's rules of procedure in the legislature, which actually comes from the common law, the rules of the common law, which is parliamentary practice. Oh my gosh. So when we think of like Title 42, 1983, petition for civil rights violations, oh my gosh, it's pretty much the same thing. It's just the heading part of the document of who you're addressing it to. Let me see if I can figure out how to screen share here.
Yeah.
And I'll show you one that I've just recently drafted. Just to give it, and I've got a couple of videos out there now that really break this down.
Yeah, the one you did on Monday was really good.
Yep, that's one, and then that's for the election petitions. But the other one,
and real quick, so everyone knows, Kirk has all of his stuff on. I usually follow him on Rumble because YouTube likes to do things. We all know. So if you want to see any videos that Kirk has done, it puts out there for the public. He does a live stream on Telegram on Monday nights, and then you can find those recorded videos the day after, usually on Rumble. So, and it's under Kirks Law Corner on Rumble.
Yeah, I'm on Rumble, still on Facebook, my Facebook page, YouTube, which I'm letting cool off again because I've already got 2 strikes within just like 2 months of coming back being live.
Yeah.
Let me see. How do I?
So it's on the very.
Is that present?
Yep. Hit present, and it'll ask
link to your YouTube account in our descriptions as well.
Okay, let's try this. Is that sharing for you folks?
Okay, I'll add it right now.
Yep, there it is. Yep.
Okay, so
Perfect.
here, this is what's known as the caption portion of a document. Whether you're in judicial branch, whatever, it's who it's to, who it's from, who the parties are, what your status. See, like me, this is part of my status and standing as one of the people. A business. That's what gives us political power, a taxpayer. And then I'm an officer of the state. So I have fiduciary duties, and my license specifically states I have received all of the rights and emoluments of a notary public. Okay. And then this is the proper format from Lex Parliamentary Americana, which is the parliamentary practice in the legislatures of the United States of America. It's the law and practice of the legislatures. Wow. So, brief statement of facts. 1, 2, 3. Simple. 1-page document. Prayer for relief. Demand. Wherefore the petitioner and all our side demand the following relief, and hereby instruct our public servants to discharge the duties as instructed by the people of Idaho. To do an investigation to verify my claims that the legislature in 1974 exceeded its power and abolished the unlawful and unconstitutionally created Department of Self-Governing Agencies.
Perfect.
We, the petitioners, all on our side, humbly submit this petition, and everybody signs it here. But I don't, I just made this in a format to where everybody can grasp the concept of how many, you only need one, really.
Yeah.
But here's the law. the Constitution says, here's what you did. The statement of fact, I'm accusing them of exceeding their powers by creating this.
Mm-hmm.
And that the legislature unlawfully and unconstitutionally enacted Idaho Code 67 citing their code of what I want abolished.
Yeah.
And abolish the unlawfully and unconstitutionally created our self-governing agencies. And it's just that simple.
Yeah. This
Short
is what,
and sweet.
This is what is meant by everyone in your constitutions, your state constitutions, where it states that all political power is inherent in the people. This is it right here. So if the political power is inherent in we the people, well, we the people have the right to tell our public servants what to do.
Yes.
So let's play devil's advocate here, Kirk. So let's say you file this petition and they don't do anything. They ignore it. They don't bring it up. They just ignore it. What's the next step from there?
Okay. So there's a couple different things that can be done. One, a writ of mandamus to the Supreme Court. Now, writ of mandamus is the polar opposite of writ of prohibition. Prohibition is to prohibit, cease and desist. Mandamus is to instruct, to discharge the duties of their office.
Mm-hmm.
Okay. So if the state legislature doesn't take up your petition to redress your grievances and follow the law, due process of law, when it's proper before them, writ of mandamus to instruct the legislature to discharge the duties of their office. Now you've got an order for them to do their job. That's contempt of court if they don't do that. Where do we go from there? If we petition the legislature for on application of the executive.
Mm-hmm.
I don't need to go back to the judicial branch. No. This is internal insurrection.
Yeah.
An attempt to overthrow the Constitution, the laws of its creation, which is where the delegations of powers are, for us to exercise our powers and rights, instruct our representatives, and that's a contempt of my order for them to do that. That goes straight to the executive. You really want to get serious about it, which the executive is the commander-in-chief, national.
Mm-hmm.
Or, as it says in Article 4, Congress. So you could basically take the same petition and the order and add to it that this is internal insurrection to Congress, and then Congress has to do an investigation. And if they don't do that, then we go straight to the executive and say, look, Commander-in-Chief, you've got to determine which is the lawful government here and who has been arrayed.
Mm-hmm. Yeah. You're talking the federal Congress, correct?
Yes. That's Article 4, Section 4. It goes to Congress to provide
federal
oversight of the states, right? To make sure that we are guaranteed a Republican form of government, and that part of all political power being inherent in the people and having the right to alter, reform, or abolish anything at any time we deem it necessary is carried out following due process of law. And if they're not discharging the duties of their office, that is internal insurrection.
Yeah. One other thought that came to mind too is if you play this process, right, you file this petition with the legislature and they don't do anything, you get a petition for a writ of mandamus, or mandamus, however you prefer to pronounce it.
Mandamus.
Mandamus. And they still don't do anything. Would you then at that point, obviously, the right dictates to go to Congress, but would you simultaneously go back to the court and say, hey, I'm filing a motion to compel or a motion to show cause why they shouldn't be held in contempt of this order?
No.
Is that an option that you could look at too?
No. Ignorance of the law, the two maxims of law. Ignorance of the law is no excuse, and to know, be bound to know it, or regarded in law as equivalent. I'm not going to play this game with them. I've got my order. They were ordered to do it to begin with. First of all, I had the right to demand this relief from the legislature itself, because that's the power that is inherent in the people. And I'm declaring that I'm one of the people, taxpayer. That makes me the boss. I'm the master. They're the servants. Servants don't get to dictate to the masters what their job description is and what their duties are to perform. We, the people, dictate to them in the Constitution itself, as well as enumerating those rights. That's all for them. Our rights, all right, we have so many rights. Ninth Amendment, or Article the Ninth. James Madison in the convention. There's so many rights to try to enumerate, it would be impossible to enumerate them all.
Yes.
So that's the savings clause of the Ninth, right? But again, those are all more like political rights stuff. And that's part of the Constitution. It has nothing to do with man in the private or the people, except for when we go to use, claim, and exercise those rights in the Constitution. Otherwise, man is in the private at suits at common law, suits between man and man, which is a whole different body of law. It has nothing to do with the Constitution.
Yep. Yeah, and that's where it can get really confusing.
Yes.
I know that in some of the lawsuits that I'm litigating now, right? I mean, when you put the defendants on there, you have to list their individual capacity, their official capacity, this and that, and some people are like, oh my gosh, my head is killing me. Isn't this just another man? Isn't that what this case is here, right? Because to Kirk's point, under the common law, you can't sue a corporation because a corporation has no rights. They have privileges assigned to them as they are created by the states that are created under them, which is why if you're trying to go after the corporation, you can't use a common law cause of action. But you can if you're going after an individual or another man or a woman that violated your rights, right? You can do that. So this is where it gets really confusing. And you know, and I'm just sitting here and I'm actually shocked. Maybe I'm missing something here. I'm not seeing any comments. Has anybody posted any comments or questions? Normally we get quite a few.
Yeah, no.
So I find it fascinating that we haven't had any questions or comments from anybody. We've got quite a few people who are live streaming this right now. But the purpose of this, you guys, is we got to start doing this the proper way. I know in my lifetime, I have never seen anyone petition the legislature. Never.
Wow.
Now,
I think it's a confusing subject, James. I think people, because I'm sitting here, that's why I'm so quiet. Normally I'm trying to ask the basic questions for the newbies, and I'm just trying to wrap my head around this because we all want to go after the justices that are committing the crimes because so many people are not getting a fair shake in court right now. And we all want to go after it, but it's a lot to swallow.
Well, and it is. I mean, it can be this is the thing is the Bar Association, and I have said this before, and I'll say it again, the most evil organization on the planet. They have taken a simple process. You know, they've gone away from the whole KISS theory, right? Keep it simple, stupid. No, they wanted let's make this as complicated as possible. Let's make people think that this is so complicated that they can't do anything without one of us. That's what they've done. Exactly. But it's not as hard as it may sound. I mean, you saw that petition that Kirk has. That's a 2-page document. You know, you don't need to file a 57-page document petition with the legislature. I mean, you don't even have to do that. You can just put, hey, these are the statement of facts. The Constitution says this. We, the people, have this right. We, the people, hold all the power. We, the people, demand this.
So, Kirk, do you file that with an affidavit as well?
That is the statement of facts right there.
Okay, so it's
see, there's a little bit different. This is from the common law. When you sign that essentially is the statement of facts.
Okay, so you're getting it notarized as well, and
now this is where, like, okay, let's curtail this to a traffic case, and we'll pick up where I left off there. You've created your record, you did your writ of prohibition, and even the Supreme Court says no, they had jurisdiction. Fine, okay, I've got my record that I followed due process of law. I have exhausted all of my remedies. I don't have to appeal to the next court. Not for this. This goes directly to the legislature because the legislature is the one that created those inferior courts.
Article 1.
Therefore, they provide oversight of that which they create. This gets back to comprehending, understanding our Republican form of government and which branch of the government has what powers and what our rights dictate. What the law dictates is the process and who has what powers. They want us to go to their code, the Idaho Code. Well, Idaho Code says, well, that's not law. First of all, Peterson versus Peterson, Idaho Supreme Court, Judge Eisman, 2014. The Idaho Code is not the law. Why? Because the Code Commission has no legislative authority. Well, who in the heck is this Code Commission? Oh, well, that's made up of 7 members of the bar selected by the governor. And that Code Commission selects 3 members of the bar to write the Idaho Code and publish it. That seems a little odd, considering I thought the legislature is the one that's supposed to make statutes, and the Secretary of State is the one that's supposed to publish the law. Oh, that goes back to that fundamental principle of a right to our Republican form of government, Virginia Declaration of Rights, June 12, 1776, that no man or set of men are entitled to separate emoluments or privileges. That's a foreign emolument, and they all hold the title of nobility of Esquire, back to Article 1, Section 9, Clause 8. I don't even need the Article the 13th, the original Article the 13th, that says if you do take a title of nobility, you cease to be a citizen of the United States, and you can no longer hold any office of public trust. Period. You're done. That was just the remedy, a relief, based on what was already in the Constitution as a prohibition. It's already in Article 1, Section 9, Clause 8.
Yeah.
And right after the no titles of nobility is emoluments. So this is what Chris picked up on and taught me about the word emolument, even how to say the word. But
yeah, that's a hard word to say.
well, I thought that when I first was reading it, I thought it had an L in there in between some there. So I was emoluments, and I'm like, no, emoluments.
Emoluments.
Oh, okay.
Hey, Justice, real quick. I just looked up in our Telegram chat. It's saying that the chat has been disabled for the live stream. Do you know anything about that?
No.
This is the first I've heard of this. I got 5 people that have posted in our chat on Telegram that says that it says the chat is disabled in YouTube, and I've never seen that. So I don't know if you can look into that while we're chatting.
It's very interesting because when we started the broadcast, it wouldn't allow me to broadcast to Rumble. I had to disconnect it. It told me it was unable, and I had to connect it to our Cloud Hub account. You'll go to Cloud Hub and see, and if I can get some comments out of the Cloud Hub chat, there should be a chat option there. Yeah. I'll just go ahead and ask them point blank. Yeah. Yes, very interesting, isn't it?
Yeah, maybe you can. I don't know if there's anything we can do. Look into that while Kirk is talking. So that's
I'll look into that. That's interesting.
Anyway, so Kirk, you were talking about emoluments. Yeah.
So an emolument is any advantage, profit, or gain received due to one's position of employment or holding of office. So this is where we get into what's really going on. Is they're making false claims on the trust. Oh, well, you did this over here. Well, my question is that not a bill of attainder, bills of pains and penalties?
Yeah.
That's legislation that prescribes punishment. Where's the man who has standing to claim a right to a cause of action here? That probable cause that's in the 4th Amendment, supported by oath or affirmation?
Yep.
Where is the man who has standing to claim a cause of action, probable cause? Because an officer is an agent. He has to have a principle to act on behalf of.
Yes.
Maxim of law. What I cannot do in my person, I cannot do through the agency of another. You have to have principle and agent. So, who are you acting on behalf of? Oh, well, we're prosecuting by information. No. 6th Amendment prohibits that.
Yep.
No, you have to have an indictment. Criminal Practice Act of 1864. Felonies and misdemeanors, all of them must be prosecuted by indictment. Where's the grand jury indictment?
Yep.
You just violated my right to due process of law.
Indictments are only issued by a grand jury.
Bingo.
Exactly. Yep. And to your point, Kirk, the Idaho State Supreme Court recently issued a very interesting ruling. It was in 2019, and I can't remember. I think it's State v. Clark. Do you remember that decision? This is actually, I actually included it in one of our court filings, challenging the jurisdiction. In this case, this woman I've been helping. The situation is a domestic violence dispute. Well, in that decision, in State v. Clark, the United States Supreme Court said that while domestic violence is a very serious issue, that the very powerful policies of the policy agents or the police departments must yield to the 4th Amendment requirements of the Constitution. So basically what the court said is unless that police officer sees the domestic violence himself, unless he's right there witnessing that crime, he has no right to effect an arrest.
Bingo.
None.
Bingo.
So
But
that's
where does
exactly
that law? Where does that law come from?
which law you talking the policy, the code? Oh yeah, the code.
No.
Yes.
No. What you just said that the officer can't make an arrest unless it happens directly in front of him. What's the law that says that?
Oh, that's the Fourth Amendment. That's the
common law.
Oh, excuse me, the common. Yes. Well, I
Yes.
mean, the Fourth Amendment is based on the common law. That's why I was
Well,
pointing
again,
that out.
American Jurisprudence, Volume 16, Constitutional Law, Section 100, Bills of Rights and those merely declaratory of the common law.
Yes.
Okay, so this is where I destroy the bar members' arguments about, well, the common law is case law, stare decisis. Really?
No.
Explain Article the 7th then, suits at common law. Are you saying that this is a suit at case law, suit at stare decisis? and they all, the three of them that I've done this to now, they all just turn around and walk away because they can't answer the question.
And they have no argument.
We're not a monarchy here. We have American common law, which started in 1606 with the first charter of Virginia. Okay. We started building our American common law, trying to separate from Catholicism, even clear back to the Magna Carta. If people were to read the Magna Carta and fully comprehend what was going on there, it is to separate from the Roman Catholic Church. The good Christian people are trying to separate. And this is what was going on is we were all refugees. We were fleeing from Great Britain, from England, to settle upon these new lands, to get away from the king, from the Roman civil law, from Catholicism, where the king is the sovereign. We want God to be the sovereign, and we want to, everything that we do, we want to be in reverence to God, not to the king.
Yes. I mean, this is fantastic, Kirk. So I really appreciate you jumping on with us. So now that we have this understanding, and this is what I would implore those of you who are listening. You guys know I'm a man of action. When I hear something, I'm like, okay, this is great. How do I do it? Which is why every time I post anything into a court filing, I post it in my Telegram chat. You guys, if I come up with something, I'm going to put it there for you. So I'm going to do the same thing here. Utah, right now, where I'm at, we are right in the middle of our legislative session. And our Utah legislature is trying to ram through 1,000 plus bills that they want to claim they can do to we the people of Utah. Now, I've got a lot of really good friends that have been maintaining closely, and they're like, hey, you guys got to show up to these committees. You got to let them know you don't want to do this.
Yes.
Guys, it doesn't matter. Even if you show up and you just express your concerns, they don't care. They're just going to keep, I mean, they're going to do like what they did to my good friend Mike Brown, that those of you who are listening know about. You know, he was unlawfully removed from a meeting because, for one, he dared to wear a sticker, and two, he dared to question the authority. Now I've got some moron who's trying to rewrite the policy of the legislature and make it apply to the public. That's not how this works. Yeah. And this is where, and I want Kirk's take on this, is we have a redress of grievance for existing policy. But if there's something that they're doing now that's currently that you want to put a stop to, from my understanding, that's a petition for a remonstrance, correct?
No. Petition is one thing. That's a political lawsuit and has a prayer for relief.
Okay.
A remonstrance, pay attention here, folks. A remonstrance is a formal written protest.
Got it.
That's how we protest. Not out on the street corner holding signs. That's called picketing, which leads into rioting.
Which leads into
We're
violence.
supposed to be a civilized society here.
Yeah.
Now, I get that people want to come together and stand up. I get that. But how many times have you heard, or even yourself, no, they're violating my rights to due process of law? Well, then why aren't you following due process of law? You become just as culpable and just as bad as them that you're accusing of, those without sin may cast the first stone. So you got to remain in honor. You have to follow the process that is due to them, which is a totally different process than the part of the common law suits between man and man. This is where we have to go look at our rights that are enumerated in our declarations of rights. We have to look at the Constitution for the process that is due. For elected officials, you have to go to the House for impeachment, because the sole power of impeachment is in the House. The sole power to try all impeachments is in the Senate. So the Constitution dictates that process. And what we have to comprehend is why. Why is that process there? Why did our founders write that? If we go back to the Declaration of Independence, one of their causes for the separation was because the king was coming in, or the prince was coming in and dissolving the entire legislative houses and instituting the king's men or the prince's men in there, and then fundamentally altering our form of government, subjecting us to pretended acts of legislation, fundamentally altering our government. That's the reason why they did that, is so that's to prevent having our entire legislatures being wiped out by the governor.
Yeah.
By the prince, by the king. No. You're going to have to go through this process. I've been duly elected. We're implementing this process. Says you can't just act arbitrarily, and we're going to keep the power over here in the legislature and take it away from the executive and the judicial.
Yeah, you got to realize,
we're going to retain this power.
You got to realize, people, the fear of the founders of someone retaining so much power. I mean, they had just overthrown a tyrant.
Yes.
And when you read their documentation, when you read the Federalist Papers, when you read, I implore every single one of you listening or watching, go read Jefferson's first draft of the Declaration of Independence. Not the one that we all know today. Read his first draft. You're going to find 5 or 6 paragraphs of a scathing rebuke of the king and his institution of slavery. You're going to see that.
Yes.
So you're going to know who Jefferson really was. But the point that I'm trying to make is they had such a fear that some point and sometime someone would have too much power, that the rights of the people would be abrogated. That's why they instituted these processes. Now, I want to go off and here in a little bit, and then we'll wrap things up for the day, Kirk. But there is a big move right now, and I'm sure you've seen this, for a convention of states. I'm sure you've heard about this, where they're proposing a convention of the states. You know, that's one of the provisions that was outlined in the Constitution. I believe it was Madison that included that, if memory serves. I can't remember, and I apologize if I'm misquoting that. Yeah. But I have major concerns. Yeah, I have major concerns with that, and I'll tell you why. Because they keep saying that the Constitution is flawed. This or that. We need to add this. We need to put in these. We need to do this. You know, I would implore everyone to just take a step back and think, okay, is the Constitution really the problem, or is the Constitution the solution? When you read the Constitution as it's written, when you read it as it's written and you understand it as, I mean, here's the thing, is they wrote that thing in plain common language that anybody could understand, anyone of common intelligence can understand. The Constitution is not the problem. The Constitution is the solution. And I don't know if you've heard of these folks, Kirk, but there's a great society. It's called the John Birch Society. They have a YouTube series on the Constitution as a solution. It's a lecture. I implore everybody to listen to it, because you'll find the small, simple pieces that have been taken out to usurp the power. And I'll just give you one example. Senators were never elected, or were never meant to be elected directly by the people.
Bingo.
They were meant to be that check and balance between the federal government and the state. They were meant to answer to the states. So that is the purpose of that. You'll also understand when you read that and when you see that series that, you know, everybody says, well, I have a Second Amendment right to keep and bear arms. Well, that's right, you do. But there's a reason behind that, because you have to understand that the colonials had just overthrown the world's most powerful standing army at the time. And there were redcoats in everybody's house, everywhere. Their biggest fear was a standing army. When you read the Constitution, you'll see that an army is only supposed to be raised in times of war, and they're only supposed to be there for 2 years.
Yep, absolutely.
Because we, the people, are supposed to be the militia. We're the people who are supposed to be at the ready to defend the homeland. So
I
when
was
you
just
look
going to
at the
get to that. Is that
Constitution, when you look at it as it's written, you're just like, oh my gosh, I knew these guys were geniuses, but they were way ahead of their time. How they even thought of these things, it just blows your mind. So I know that was a really long segue, but what are your thoughts on this whole Convention of States movement that I keep getting stuff all the time? What are your thoughts on that?
Well, I'd like to lead over to where we talked about before starting here. Is the fact is how do you have a convention of states when it's still government de facto and we haven't reassembled the government de jure?
That's a good point.
Where are the legitimate states? Where's the people? This is still all under the government de facto from 1871. We need to reassemble and see. This is even Trump. He said, when this is all said and done, you're going to have a government that nobody's going to recognize.
Yeah.
Now, based on what my research and study has been over the last year now of how this is really supposed to be, that all political power is inherent in the people, we're supposed to be the first branch of government. Back to the Magna Carta, Chapter 61, the common law grand jury, 20 and 5 men.
Mm-hmm.
So with national-assembly.net, which I've been, trying to find these kinds of people since 2014 when I found Carl Miller.
Yeah.
And he talked about this kind of stuff. And I'm like, wait a minute, where are they? I found other people out there. I want to name names, but I have finally found the one legitimate one who has the support of the military, who has done 11 requisitions to Trump, who denied Obama to invade Syria. So can any of these other groups show any kind of legitimacy to them and have the military support? No. So I finally found the real ones. And in fact, it was part of what Carl Miller was part of till he passed away here a couple of years ago. And in fact, Carl Miller lived with a man named Destry, who's part of stuff that behind this, trying to get people to come together to do this for over 2 years.
Mm-hmm.
I'm like, holy crap, you knew Carl? I'm like, man, I wish I could have met him. Great man, trying to teach us, which all comes essentially from the military Project Blue Book.
Yeah. Yeah. Okay. Carl's a great guy.
Yes, I love him. He's the one that inspired me to do this because I was sitting there watching his video and he's like, oh, you got to learn this stuff just like in the military, Marine Corps. I had to memorize certain things, but he was saying you got to study this stuff. You got to commit it to memory. And I'm thinking, man, I'm getting old. I don't know how well my brain's going to function here. And I'm 51, still going like crazy over here. Yep. And then he said, well, somebody ought to do something about that. Be a somebody.
Mm-hmm.
So here I am going, oh, all right, Carl, I'm picking up what you're laying down. I'll start studying harder and really doing a deep dive, going into the history and just like, I'll do what I can. He inspired me to really start putting this stuff to memory. And now I'm a freaking walking encyclopedia because I just read and read and read. And I'm not kidding. For the last, since about 2014, 2017, pretty much totally have dedicated my life to reading, educating myself, and trying to educate my fellow man and take actions.
Yeah. For those of you who are watching, I just put on the screen here the National Assembly.net. There's a hyphen there, so it's national-assembly.net. This is their homepage. Under the states' websites, you'll see the states that have assembled, as we're talking about here. My favorite tab here is the state national fraud. I know that's been a big push by a lot of people.
Yes.
And it never made sense to me from the very beginning. You all know my thoughts on that. Just suffice it to say, there's nothing there. There's nothing there. It's not going to make. And I've said this before too. There's no magic pill, magic document that you can do. That's just that you can show any one of these policy enforcers that wear badges and have guns. There's nothing that you can show them to go, oh, you can't touch me. That's just not how it works. So great information on this site. Full disclosure, I haven't had a lot of time to dive into this site. I'm going to. Because again, if we want to stand up and we want to ensure our republic, we do it the right way. Now, the good news is I'm seeing some positive things coming. There are some good people that are leading the charge. There are some, I mean, as weird as this may sound, there are actually some good people in the federal Congress that are making changes.
Absolutely.
Now, I may not have 100% confidence in everything that they do, but when I see the little things that they do, I start to go, okay, hey, this is moving in the right direction. I'll give you a good example. Jim Jordan is one of those men. You know, I mean, he's always been a no nonsense, just like, who the crap are you? Where do you think you're coming from? Yeah. You just need to sit down and shut up. And he's actually done that recently. Yeah. You know, Matt Gaetz is another one who, you know, most people will look at him and say, why in the world did you hold out? Matt Gaetz held out from confirming Kevin McCarthy as Speaker of the House. And guess what he got? He got a bunch of concessions. I guarantee you Kevin McCarthy did not want to do the things that he is doing now. But Matt Gaetz says, hey, you're going to do it. Yep. Because I promised my constituents. So there are good people, but they are few and far between. And this ship is so far off course. It's going to take a lot to get it back on course, but it's not lost. And the answer, people, is not picking up guns and marching in massive amounts of people and shooting at other. That is not the answer. That is not the protest we're talking about.
Right in the Virginia Declaration of Rights, June 12, 1776, we are supposed to be a nation without the use of force and violence. Exactly. We're supposed to have Christian love, charity, and forbearance.
Exactly.
Turn the other cheek, follow due process of law, remain in honor, and do not enter into sin, so you have clean hands. That's that. Those without sin may cast the first stone, cause of action, to pick up the stone and throw it. The clean hands doctrine. You got to make sure your hands are clean. Don't go walking into the court or the legislature like you've been out in the back pasture giving suppositories to cattle all day and try to come in here and stink up the courtroom.
I just got this nasty image in my mind.
I love that analogy because, you know, I've kind of been around farming I was
going to say, you're an Idaho boy. You've been around farms. I know that. So,
yep.
That's crazy. So, guys, as we wrap things up here, first of all, Kirk, thank you so much for taking some time out of your Friday afternoon. I know you're super busy. You got a couple of cases right now where they're coming after you for who knows what, right?
Yeah, I've got one left. I've actually had my last 4 cases dismissed.
Good.
2 of them were for not wearing a mask. Those got dismissed. The other one was the domestic violence protection order, which I went to court and basically with her on the stand asked her specific questions about, did you submit any evidence here today to support your claims? Well, no. So you have no evidence you've submitted here to support your judge dismissed all of her claims.
Good.
Okay, but he still granted supposedly for my son based on other things. But I put them all on notice of intent to sue right after receiving the protection order. And then they tried to say I was in violation of the protection order, issued a warrant supposedly. But see, I know that this is all de facto anyway, and it's not lawful to begin with. And that's a whole nother show that we can talk about the Violence Against Women Act and what I've already done and where I'm going to be doing something about that this year. But the fact is, they tried to tell me, oh, well, you have a warrant down here. And I said, I don't have time for that today. So they actually didn't have a legitimate warrant or they would have actually arrested me. 3.5 years later, now you want to try to bring this up. Yeah. Dismissed. I was like, how do you have a cause of action for a violation of protection order that you didn't grant?
Yeah.
You said with her sitting on the stand that you were dismissing all of her claims. Now, I had warned that judge at the very beginning before the trial that this petition is riddled with false statements, all signed under penalty of perjury.
Yep.
I brought up the Idaho Judicial Rules of Code of Conduct that the attorneys can't represent fraud. And this becomes, and I cited that and they started scrambling like, what? Yeah. Reading means reading, folks, and speaking the law, especially the stuff that really just kind of jabs them in the side there, whips them into line. Well, I tell you what, they were scrambling like nobody's business. And I said, that's perjury and subordination of perjury. And then I brought it up again. I'm like, you said that you were dismissing all of her claims. And then the unsubstantiated claim letter from CPS, nothing was proved. That was all under penalties of perjury and subordination of perjury. You were informed of the crimes to begin with. Then it went through trial, these de facto kangaroo court trials, these star chambers, and you did nothing about it. That's misprison of felony. Now you're culpable. Even 3.5 years later, it doesn't matter because I'm still being injured by that. So anyway, that one got dismissed. And then the driving without privileges back in 2014 was dismissed. Now, the current case that I have right now stems from not having or having expired tags. Then they went into driving without privileges, no insurance, revoked registration or failed to register, and expired tags. And then the resisting and obstructing. Well, the prosecutor didn't file any of the traffic tickets because there's a bar to any other prosecution for the same stuff from 2014. So they didn't even file any of the traffic tickets other than the resisting and obstructing.
Oh my goodness.
So,
anyway, it's amazing.
Yeah.
That's awesome. It's amazing when you see this stuff, guys. Just how terrible these people are. I'm trying to see if I can find it real quick, but I wanted to show you, Kirk, one of my friends. I don't think it's here. Dang it, I can't find it. Anyway, one of my friends, he's been on the show. His name is Kevin Hall. He's a retired lieutenant colonel in the Air Force, served honorably. He too was pulled over for expired tags. And he, knowing what he knew, now, again, he's not as well versed in the law as like you are, but he's studying, and he and I've known each other for a while. So he took one of my documents, one of my motions to dismiss that I had done earlier. It was really poorly written, but he changed it, thankfully. So he went in and he started reading the code, right? And he found this little nugget that said, you are not required to register your car if you are crossing the highway from one property to another. Well, wait a second. Isn't that what we're doing every single time we get in our personal car?
Property?
Go from one property to another? That's the argument he made. The other side never bothered to reply to it, like they never do. And he said, okay, I'm moving for this court for default. And he was granted. They dismissed the case. The judge actually is like, they didn't do what they're supposed to do according to the rules of procedure, but still. Yeah. So it's funny when you start diving into this stuff and you see how ridiculous this thing is. But it's, again, guys, these injustice courts, these municipal courts, whatever you want to call them, this is merely it's a terrible business, but it's a business. To them, they're just processing people as quickly as they can. They never even bother to read the code. I'll give you a quick example, and then we'll wrap up this conversation. My friend, who I'm helping right now down in southern Utah, there was a newly, I think it was last year, the Utah legislature updated the code regarding jail release agreements issued in response to domestic violence. So it states that, you have to agree you can't have any contact with the victim, blah, 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 blah. But it also, within that same code, states that the victim can waive those rights. They can waive those provisions of that jail release agreement. And the prosecution is deliberately trying to hide that information because the alleged defendant, she has now requested 5 different times from her defense attorney, get me a copy of these forms. Because what happened was, when she was released from jail, her ex-boyfriend at the time, her ex-boyfriend now, but he was a boyfriend at the time, the one who was allegedly the victim, came and said, I'm not pressing charges. I don't want this woman anything to happen. They are still moving these cases through the system. And he's not pressing charges. And he's the supposed victim. So he was required to sign documentation to go to take her. And I know for a fact he waived those rights, but they will not give us that information. Now you tell me, how is this proper due process of law? Because it's not.
See, it's not. And see, this goes back to, the Spanish Inquisition and the Star Chambers. That's what all this stuff is. Back to the Roman civil law crap. Okay. Again, what's the subject matter here? Domestic violence. Yeah. Article 4, Section 4 says domestic violence is internal insurrection. Now, see, I've already posed this in a case. Does Congress have the authority to redefine what domestic violence is? The answer is no.
They do
Does
not.
Congress have the authority to create due process of law? The answer is no. That's off limits. Law of Nations, Book 1, Chapter 3, Section 34. The question was asked, does the legislature have the authority to alter the fundamental law or the Constitution? The answer is no, because that which is created cannot alter the laws of its own creation.
Yeah.
We did not delegate personal jurisdiction over man or the people. We also did not delegate subject matter jurisdiction over any of our rights, which due process of law comes from our rights, not from a statute. They have no authority to create the Violence Against Women Act, which, by the way, was declared to be unconstitutional in U.S. versus Morrison back in 2000. And then Congress decided to reauthorize the Violence Against Women Act in 2005. How do you reauthorize something
that was found unconstitutional?
To be unconstitutional to begin with. But nobody, see, this is the thing, is all the bar members are doing this, and they're doing some good, right? They're trying. But the reality is we need to come in and go, where is Congress's authority to redefine what domestic violence is? And in fact, what they actually did by creating the Violence Against Women Act is internal insurrection to war against the people. And this goes back to Saul Alinsky's Rules for Radicals to destroy the family. When you're talking about these supposed domestic violence petitions, where's the criminal complaint? Because we can get orders of protection through a criminal complaint. And the real law is the common law, and those are called breaches of the peace, which are assaults and batteries. It's already the law.
It's already there.
The real law, the common law.
Yeah.
Not the Violence Against Women Act. That's using women and children as human shields, one, to deprive the fundamental right to keep and bear arms, which comes from the laws of nature, right of self-defense, the 6 primitive laws of nature. Okay? That's the body of law we're talking about. The right of keeping and bearing arms comes from the laws of nature as a fundamental principle of law.
Yeah.
I don't need the Second Amendment for that right. It's already fundamental.
Yep. But see, this is again going back to what we talked about before. This is what the founders knew. They knew somebody would come along and say, "Oh, you don't have that right. You can't do that." So they're like, "Hey, we have to," because people are stupid. Let's just be honest. People are stupid.
I like to use the word ignorant because we just don't know.
Ignorant is probably a less harsh term, but I don't care.
Yeah, it's not a derogatory term. It just means we just don't know. There's lots of things I'm ignorant about. Yeah.
Right? Well, I'm referring to people who think they have power and really don't. Those are the people I'm saying. Those people are stupid.
Yeah.
Like we recently in the news, there was the ATF is just coming out with some new regulation. Great. You can take that regulation and shove it where the sun don't shine. It means nothing to me. You have no authority to do anything to me. And I don't care what you think you can do. That's not how this works. It just does not work that way. But going back to what we're saying, if it's not an enumerated power, enumerated, all that means is written down. If that's not something that we gave, if that's not a power that we granted to them, they don't have it. End of the freaking story.
Yep.
And this is why we need to step up and take this. Justice, you have something you want to say?
Well, that's what you were saying in the beginning of the broadcast is just, and this is what we've been witnessing, is that they're going to do it unless someone steps up and stops them. And America, everyone, you all have to stop waiting for the military or waiting for all of this stuff and just get locally. If someone stand with some, I have a girlfriend who the sexual books in school. I said, I don't have kids in school, but I'll go with you. I'll go to the sheriff's. I'll go support somebody. Do something, make an effort locally. This is how it stops. Listening to gentlemen like this that have the knowledge, one bite at a time.
Yeah.
Perfect example, which I'm going to be doing this in Idaho. Idaho Constitution specifically says that the legislature is supposed to create one board of education, and they're supposed to create the curriculum for the schools, and it's supposed to be uniform throughout the state. Why do we have all these other school boards, and what's with all this different curriculum and all this? No. And I've already talked to one of my representatives just here last week. No, 2 weeks ago now. And said, look, do you want to work with me on this? Because this is what it says. I'm coming in with petitions, whether you guys want to work with me or not. But I'm looking for allies. And if you don't want to get on board here, I'm going to the military.
Yeah.
Because this is internal insurrection.
Mhm.
Yes, it is.
And I've been warning my good people representatives here in Idaho for almost 3 years. And a couple of them have come out flat out and said, well, why don't you just do something about it? Because it's your job. And I'm instructing you to do it.
Exactly.
Right. When it gets to a certain
you
level.
don't want to do your job. You won't stop refraining from doing what you're doing, creating this code that you seem to think that you're making law, and it's not. You're being deceived. And none of them have actually read the frickin' Idaho Constitution.
Yeah.
How do you not know the laws of your own creation and the limitations of your powers? How do you not know that and receive the emoluments of that office? How do you, in good conscience, receive a paycheck?
Yeah,
Well,
it's here's what I would challenge. I would challenge those of you who are listening or watching. Usually this time of the year, and it depends on every state. Your state's going to be in session. Your legislative branches are going to be in session. The House of Representatives and the Senate. I would challenge you to find any proposed legislation that wasn't written by a member of the bar. I would challenge you, because I have yet to find anything. And these people know this. They know this. What, again, the bar, I said it before, I'll say it again, and I will say this till the day I die. They are the most evil organization on the planet because they control everything. And this was made painfully evident to me when I was watching a video once, and there was this new young lawyer who just got his law license, and he was standing up in Seattle somewhere, and they're looking over the city, and one of the named partners comes up and puts his arm around him and says, hey, who do you think controls all of that stuff out there? You know, and he starts giving, he's like, well, you know, the mayor, this or that and everything else. And he goes, nope, wrong. We do. And he said, the guy looked back at him and he's like, are you serious? He's like, everything that's out there that governs the world we live in, lawyers wrote it. We do this. And so he took a step back, pulled out his bar card, tore it up and said, if that's the case, I don't want to be a part of it. And he left.
Yeah.
So
let me ask you a question.
That was a good movie.
Yeah.
When did you discover that the bar was at the root of our problems here? And how did you discover when did that happen? How did you get down that rabbit hole and discover that?
For me, that was about, let's see, what year is it, Justice? 2023 now?
Yes.
It was in about June, July-ish of 2020. So when
fairly recent.
Yeah, I mean, this has only been a few years for me. It was, you know, seeing the garbage that was going on. And I'm not going to rehash that. We all know the deals. And I was just like, there's no way this is right. And so when I started looking into things and started following some more, you know, it's just one door leads in, opens to another, and to another. And I finally was able to put two and two together. And then I realized, like, wait a second. Because again, you know, in my past, you know, I held a real estate license. And when you practice real estate, and you bring on a new client, you have a fiduciary duty to do what is in the best interest of that client. Absolutely. But then when I was looking at attorneys, when you hire an attorney, that fiduciary clause is not there. I was like, wait a second. This is people's lives in some case. Some people are looking at serious jail time. How is it that this licensed attorney is not required to do what's in their best interest? No, it's because their first allegiance lies to the bar organization. And so then I step back and I go, okay, so on one side of the table, you've got the defense attorney, bar member. On one side of the table, you have the prosecutor, bar member, and the alleged referee, who's supposed to just be impartial, 9 times out of 10 is still a bar member. How are you supposed to get remedy?
Sounds like a conflict of interest to me. Sounds like a racketeering scheme, human trafficking, part B, debt, slaves, and peonage. Yep. And it's all the code enforcing bills of attainers and bills of pains and penalties, fundamentally altering our form of government and subjecting us to pretended acts of legislation. Yep. Now, how is it? Yeah. Now, you and I just essentially just met, right?
Yeah. Yeah. We just talked on Sunday. Yeah.
Right. So how is it? Here's another 2 men that, possessing logic and reason, have come to a reasonable conclusion based in reality that the bar is at the root of the problem here. How is that? Where do you live? I live in
just outside of Ogden here in Utah.
Okay, so you're not too far away from me, Idaho, but you're still several miles from me. And like Chris, he lived in Florida. Okay, how is it that Chris and I came to the same reasonable conclusion based in reality? Opposite ends of the United States of America here, not knowing each other before we talked, that we come to that reasonable conclusion. The same thing with what you've done.
Yeah.
So now
Yeah.
there's three men that have come to the same reasonable conclusion based in reality here, that the bar is at the root of the problem.
Yeah.
Why are we not discussing that?
Well, and more people are, you
Yeah.
know, there's, we had, Dr. Frederick Graves was on with us a while ago. He's, full disclosure, he's still a member of the bar,
Yep.
but he has seen the problems with the bar. And matter of fact, he just posted in our Telegram channel. He says the theater of the power of the people is in the courts, and we must teach what the bar has hidden too long already.
But
So
it's
he
not
gets
in
that
the
too.
courts.
But he again, we got to remember, this is a bar attorney. He thinks the courts is where you go for everything.
Why does the right dictate that we petition the legislature for the redress of grievance? It doesn't say judicial branch.
No.
It specifically says the legislature.
Yes, it does.
There are three distinct branches of our form of government here. The legislative branch is the first branch, which the people is part of the General Assembly, where the common law courts or common law judicial or grand jury
There you
is
go.
supposed to come from.
Mhm.
It's also supposed to be where our common law courts are from, where we're supposed to have our petite juries and judging the law and the facts, which is
Yes.
still enumerated in Texas Constitution.
It is.
So
It is.
in a sense, yes, the judicial, but this would be on the first branch of government, the power retained by the people in the private to conduct our common law courts to abolish legislation made by the legislature or any actions taken by the executive or the judicial branch under admiralty jurisdiction, like it says in the Article the 7th, cannot otherwise be re-examined in any courts of the United States, except
even
for
the
pursuant
Supreme
to the
Court.
rule of the common law. So this is all supposed to be done by the people in the private in a common law court, judging both the law and the facts.
Mm-hmm.
And then if there's a problem from there, then it can go through a what? A writ of review, which is also known as now as a writ of certiorari.
Yep.
Okay. That's how that's supposed to work to go into the courts of the United States, because Article 4, Section 3, new states may be admitted into the Union. And per the supreme law of the land, the judicial power is vested in one Supreme Court.
Yes.
And Congress has the authority to create inferior tribunals. What do you think happens when the Organic Act for the Territory of Idaho is written by Congress? They enumerate the Supreme Court, the Appellate Court, and the Justices of the Peace, the District Court and the Justice of the Peace. It's enumerated right in the Organic Act for the Territory of Idaho, 1863.
Yep.
By Congress. These are all courts of the United States. Where does it talk about our common law courts, except for the 7th Amendment?
Yep.
Because that's a totally different body of law. It's not constitutional law. It doesn't come from the Constitution. You have to assemble the common law side of our first branch of government, the legislative branch. Then we can create the Constitution. Because that's the instrument of government to secure our rights. And we draw that proverbial line in the sand and say, that's the public side.
Yes.
This is the private side. You keep your nose on the public side, and we provide oversight of what we just created.
Exactly.
If you step out of line, we drag you across the line over here into the private, and we prosecute you.
Yeah. We
We remove you from office.
Yep.
But that's only a government de jure lawfully created.
C to AZ, he or she, I can't remember. I apologize. I think it's a she. She joins us a lot. So I appreciate you being on here. And I would hope Kirk will join us again. I'm sure he will. But Kirk, thanks so much. This has been fantastic. Again, everybody that's listening, everybody that's watching, we just want to empower you. I've said this before, and I say it again. Everything that I teach, everything that I do, anybody that I bring onto the show, I want to empower you to win. I want you to walk into any of these injustice courts, any of these inferior courts of limited jurisdiction, and I want you to be able to challenge them by what authority are you moving? Because everything that I've seen here, it's as if you're trying to prosecute another corporation, another creation of the state. And last time I checked, I was not created by the state. I was created by God. So
Bingo.
if you have any evidence, again, one of my favorite lines, and I learned this from, oh, sorry, C2AZ. It's a dude. I apologize. I identify as he, him, dude.
I identify as man, creation of God. One of the people of the territory of Idaho.
Sorry. I apologize. I can never remember. I mean, all I see is your screen name, so I don't remember, and then that's my fault. But again, what I was saying, one of my favorite lines in anything is, what evidence do you have to suggest that you can prosecute me this way, or that I am a member of such and such, or that I am a creation of the state? What evidence do you have? Because at the end of the day, I mean, if there's one thing that Doc Graves does say, the rules rule in their courts, right? You stand on that, you say, hey, according to this, the rules state you must have proper evidence, one that I can inspect and one that I can cross-examine. There's nothing in the record. So how are you moving? By what authority? So that's why I wanted to bring Kirk on, because again, if we're not getting that remedy that we're supposed to, that's owed to us, that's due to us by our duty and by our rights, if we're not getting that remedy, we now have that next step. We petition the legislature. We say, hey, this thing you guys created, it's like Frankenstein. The monster has come to life. Or actually, that's Frankenstein's monster, right? Frankenstein was the doctor?
Frankenstein was the doctor.
Okay, I never remember that. We just referred to him as Frankenstein. So Frankenstein's monster has now come to life and is trying to take over Frankenstein. So
yeah. Now you mentioned KISS earlier. Keep it simple, stupid.
Yes.
So let's make this as so simple. It's so stupid simple.
Yes.
One, suits between man and man is at common law, the body of law known as the common law.
Yes.
The other part is suits in law, contract.
Yes.
That's as simple as I can make it. Where is the contract that binds me to this? Because the fundamental principle of the rule of law, which is in the Constitution, there shall be no law impairing the obligations of a contract. The exception to that rule of law is what? Fraud. Because fraud will vitiate everything from its inception, void ab initio. U.S. versus Throckmorton. It could be 10 years down the road. It doesn't matter.
It doesn't matter. Doesn't matter.
Void ab initio from its inception.
Yeah, if fraud created it.
So where's the contract that binds me to this?
Yeah, contract is everything.
It is.
So, I mean, to break it down as simple as most simple as we can, is this a suit between man and man, and where's the real party in interest? And like Dr. Graves was talking about, inter alia, okay? All of this has to come together. So what's the name of the man, the accuser that has standing?
Yep. Where's my accuser?
You probably have cause of action to act on behalf of. And then no warrant shall issue but upon probable cause supported by oath or affirmation. And this goes back to the Magna Carta, that we're not going to do this on our own bailiffs, which the bailiff was the sheriff or sharif, which we're only supposed to have a sheriff and his one deputy. No standing armies, no armed bodies of men.
Yeah.
So they're not supposed to be doing this. Again, this is prosecution by information. Bunch of garbage, bills of attainder, bills of pains and penalties. It's all human trafficking, because everything's been held in trust, and they're making false claims on the trust, saying that you did this, and the code says you did this. If you do this, this is a fine or jail time. You go to jail or you pay the fine, or both.
Either way, if you pay the fine, and go to jail, they're still making money. This is all.
But then they're writing bonds on the backside of cases to get paid. The big bond, the performance bond, and the payment bond.
Hence bail bondsman, right?
Well, it's a little bit different than that. That you're bonding the case itself, but you're also, in a sense, saying, just in case you guys mess up, now I'm going to hold you responsible. Yeah, you're going to owe me.
Yeah. Yep. Again, it's. Yeah, we just want to keep it simple. Where's the man or woman that's accusing me? Okay, that's not the case here. Great. Where's the contract? By what authority? Where's the contract?
Jurisdiction.
Yep. So, well, everybody, hey, this has been a great conversation. I always say this, Justice, you got to keep me on track, right? We try to keep these things to an hour. Here we are, an hour and 40, almost 45 minutes later.
Sometimes it warrants it. It's okay.
I know. This has been a great conversation. I've really enjoyed my time. Thank you, everybody we finally got the chat working. I apologize about that little snafu.
Yeah, it was interesting. 3 of our platforms had changed. I'm very curious about that. But anyway, it was marked for children.
What?
marked for
Yeah.
children.
Well,
And
hey,
the
we do need to be teaching our children this stuff. That
Yes, so
is
it's
we do.
disabled, but it was disabled, the comments when it's marked. Anyway, but that's
That's
back
weird.
end stuff. That's very, very odd. But
Yeah,
anyway,
that's weird.
can I just ask Kirk real quick? Would you let everybody know where they can find you, your channels and your social media, if anybody would like to reach out to you?
I actually just created the IdahoDeJure.org, just a kind of a splash page. And I have everything there. Kirks Law Corner, LLC, Kirks Law Corner on Rumble, which is one word, but I've got the link in there. And that's Idaho, DEJURE. It's pronounced de jure. It's French, .org. So
Okay.
I've got my Rumble channel on there, my Telegram channels. One's for the political power, which is the KLC American Patriots, MC main channel, trying to bring people together and learn about specifically, this is narrowly construed to just exercising political power and reassembling our de jure government. Getting people over there to the national-assembly.net to get together. We must bring unity. We have to come together and reassemble. It's our republic if we can keep it.
If we can keep it. And that's
the other part is kirkslawcorner.com. I highly recommend, even you, James, and Justice here, download Treatise on Arrest and False Imprisonment and read that, because it is heavy on the common law. It's in the form of a summons, a complaint, and a memorandum of law. There's only like 10, 12 pages. That's not a document template. And when you go read the complaint part and you read the statement of facts portion, that's the first thing that needs to be done. Write out your statement of facts of who did what, where, and when. Short, clear, concise statements of facts. Once you get that done, you can put a heading and a prayer for relief underneath and above your statement of facts and file it wherever you want to file it. Because the facts never change.
Would you say that again and let the audience know where they can find those downloads?
KirksLawCorner.com. Okay. Go to the library tab. The other one is, first one is Treatise on Arrest and False Imprisonment. The second one is the authority of law, which gets into the power of the legislatures to create a legitimate statute, not the code stuff. So you're going to learn quite a bit just by reading those two books right there. Okay. And the great legislative procedure is up there, 2010 edition, section 148. Petitioners have the right to present their own petitions. Lex Parliamentary Americana. I can't remember if I got that one on.
It's not there. It's not there. I looked for it yesterday, but you do a quick Google search for it. You'll find that archives.gov has
archives.gov. But I also have uploaded it on my Telegram channel.
Good.
So that should get people where they need to go between kirkslawcorner.com and the IdahoDeJure.org.
Good.
The .org there has all the new updated links. I've kind of not figured out how to get access to my own website, so I need to get a hold of my administrator over there when I have, those extra 12-hour days, those 36-hour days.
Well, hey, again, Kirk, thanks so much for joining us today. Appreciate you being here and bringing your wisdom. The last thing I would throw in there, people, is there are a lot of people across this great country that are trying to find that. What is it? What do I do? How do I get involved? I would say set aside your petty differences with someone else. There might be something small that even we've said today that you don't agree with. That's great. But at the end of the day, we all want our liberty. We all want to secure the liberty and for our posterity, for our children. We want to preserve this great republic. So if that's what we're trying to do, set aside your petty differences. Join with us. Watch Kirk's videos. Just get as much information as you can. And again, take stuff that you hear that you don't like with a grain of salt. It's okay. I say things all the time that people don't agree with. There's things that people say all the time that I don't agree with. That's just life. That's who we are. But I would implore each of you to take action. I'm not a big Tony Robbins fan. I don't like who he is as a human being, but I do like what he says. And he says, take massive action. Take massive action. This is it right here. You can do these things. That treatise on false arrest and imprisonment is a great read. It's a short read.
Treatise on arrest.
Oh, on
and
arrest.
false imprisonment.
On arrest and false imprisonment. Yeah, it's
a lot
great.
of people want to say it's false arrest. And no, it's just arrest. What is the law regarding lawful arrests?
Exactly.
And if it's not a lawful arrest, it becomes false imprisonment, which leads to kidnapping, which we can seek the death penalty for.
Yeah, I mean, it'll open your eyes. It's a great read, and he's right. It does have sample complaints in there. And he's right. You just write down your statement of facts. And a statement of fact is just simple. It's like, who was involved, what happened, and where did it happen, and when. That's it. And you're just going to write it. You're going to write it in a method that's just simple, concise, and it's like, this is what happened to me, and this is who was involved, and this is where it was, and this is when it happened. So, with that, everybody,
nothing but the facts, ma'am.
That's right. Just the facts. Give me the facts. Just the truth, right? And this isn't the whole Tom Cruise thing. You can't handle the truth. Oh, you can. You can handle the truth. So with that, I wish everybody
we can do this.
We can do this. With that, I will wish everybody a happy weekend. Love you all. God bless you all. And we will talk to you on the flip side, hopefully next Friday.
God bless. Thanks, James. And thanks, Justice.
Thanks, Kirk.
Thank you, Kirk. Pleasure chatting with you. Bye, everyone.